Thank you. Be seated, please. Okay, all right. Everybody again, make sure your cell phones are turned off. All right, ladies and gentlemen, jury service may be new to some of you, and if not all of you, so an explanation is in order. Those who participate in a trial must do so in accordance with established rules. That's true of the witnesses, the lawyers, and the judge. The lawyers present the evidence, and the judge applies and interprets the rules and determines what evidence may be admitted under those laws and rules. Now, you as the jurors will be the sole judges of the facts, the credibility of the witnesses that testify, and the weight to be given to the testimony and evidence. And at the end of the case, I'll instruct you regarding the law of those matters, and you will apply that law to the facts. Now, as I mentioned earlier, it is your sworn duty as yours to accept the law and follow it as is given to you by the court. Procedure for the trial will be as follows. First, the attorneys are going to outline what they expect the evidence to be. These are called opening statements. They're not evidence, but they're simply a preview, if you will, of what each party believes will be presented during the case. And they are designed to help you follow the evidence as it is presented. After opening statements, the state will offer its evidence. After the state completes its presentation, the defendant may, but is not required, to offer evidence. If the defendant does offer evidence, the state may, but is not required to present rebuttal evidence. Now, after that, the court will instruct the jury on the law. There will be closing arguments from the attorneys, and then final instructions on deliberations. And then after that, the jury will deliberate, return a verdict. Now, the procedure for questioning during the trial will be as follows. The party that calls a witness will ask questions first, and that's called direct examination. And then after that's complete, the opposing party can ask questions. That's called cross-examination. Then the party that called the witness can then ask additional questions called redirect, but those are limited to the matters that were asked about in the cross-examination. Now, jurors are not permitted to ask questions in case you might ask. Now, during the trial, attorneys will likely make objections. This is a procedure by which an attorney raises an issue of law that the judge must decide. And I apply the rules. It's not that I decide what I think is fair. I decide what the law says, based on the statutes and the rules of the Supreme Court. If an attorney objects, and then the court has to determine whether the question and or the answer are proper under the rules of the law. If I say that the objection is sustained, that means that I've determined that either the question or the answer or both cannot come into evidence. If I say overruled, then I've determined that both the question and the answer are proper under the rules, and you'll hear the answer. Now, occasionally, given the fact that trials sometimes move pretty quickly, there's a lot of back and forth, a witness may answer a question before an attorney has a chance to make an objection, or the court has a chance to rule on it. If ultimately I decide that either the question or the answer were improper, should not come in, and I sustain it, then you'll be instructed to either then or at the end of the case to disregard whatever testimony or answer was given. And that means that at the end of the case, when you're deliberating, you cannot consider it. We know that you don't, we're not like computers where we can just delete it. It's still there. But it just needs to be considered in your consideration of the case and your deliberations. Now, it's important that you be fair and attentive throughout the trial. Again, this won't be a really long trial, and so, but it's still important to be attentive. And during the breaks that we take, you are not to discuss the case with anyone else, including yourselves. And the reason for that is this: you cannot. Any discussion you have, if you were discussing the case, would be premature, because until all of the evidence is presented, until you've heard the closing arguments of counsel, the instructions of law from the court, you don't have everything that you need to make a decision. And so, therefore, you're not to discuss it during any breaks or during lunch, or if you're back in the jury room during a break, you're not to discuss it. Talk about anything other than that. Now, you're also not to discuss this with anyone else. not to text anybody about the case, or if you're on a phone call, or if you meet somebody for lunch, not to talk about the case at all. Not to talk, well, again, as I said, with any of the other individuals here. Now, once your jury duty is completed and you've reached a verdict or discharged, then at that time you'll be released from that obligation. At that time you may talk with others, but not until that time. Now, in the event that during your breaks you hear somebody discussing the case or whatever, make sure you tell them, look, I'm a juror, I can't hear that, and if they won't stop, then just move away so that you don't hear it, because they're not under the obligations you are. Generally, people will cooperate, but just make sure you bring that to their attention. You're not to read, view, or listen to any kind of a report in a newspaper, radio, television, internet, social media, podcast, etc., on the subject of this trial. I don't know that we'll have any of that, but in case there is, like if somebody might be watching the trial and posting on social media, don't read anything about that. Persons like reporters or other persons that are observing, that are posting, they're not jurors. They're not under the obligation that you are. They don't have the duty that you do. They just are basically posting what they think is interesting or something that might agree with their view of the case, but it's not evidence, and so that's why you're not permitted to have that kind of information. And in the event that something like that happen, that you should inadvertently see or hear something or somebody say something, then report to the bailiff, and then they'll report to me, and I'll discuss with the attorney to determine if there's anything needs to be taken, any action needs to be taken. Now, just to let you know, occasionally, it doesn't happen very often, but it has happened in the past, that if something like that comes up, we have to ask the juror questions. And so one of the things that I caution you on is if something comes up like that you think should be reported, make your own decision and keep it to yourself. Don't share it with your fellow jurors. And the reason for that is that 30 years ago, I was trying a case, and it was a week trial. We had 15 jurors, so we had 3 alternates. And during the lunch hour, one of the jurors was at the old McGee's across the street at that time, and somebody came up to them and started talking to them about the case. So they came back, and instead of telling the bailiff, they brought it up in the jury room and said, this person said blah, 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 blah. I reckon I should report it to the judge. And of course, everybody said, well, yeah. And they did. I can't remember if it's he or she, but whoever it was, they did. And the problem was that since they had discussed it with him, we not only had to question that individual who heard it directly, but the other 14 jurors. So as you can imagine, that took a couple hours. So it took out most of an afternoon of evidence. And so if you have any doubt, just report it, but don't ask for advice from your fellow jurors or anyone else. Okay. Now, from time to time, we will have bench conferences, as we did when we selected the jury. That means sometimes we'll be discussing a logistical issue. Sometimes it may be an argument about a point of law. And if that's the case, those things are to be discussed as much as possible outside the presence of the jury, because we don't. If I decide that what the argument's about, evidence can't come in. That's more evidence that testimony you might have to disregard, and so let's help stop that from happening so that it doesn't overburden you with things that you can't consider that you've heard. Also, since it's a trial of short duration, there will not be any note-taking permitted in this case. All right. So with that now, that completes the instructions of the court. And again, you're going to follow all those instructions during all of the breaks we take. Periodically, when we take a break, I'll either say something to the effect of remember the instructions of the court, or follow the instructions of the court during the break, or remember the admonitions of the court. And admonitions is another word we use for these. So if I do that, it just basically means you apply all the rules during the breaks. All right. We'll now proceed with the opening statements, which attorneys will offer to explain what they believe the evidence is going to be. And again, remember, these are evidence that are simply previews of what they believe the evidence is going to be. We'll start with the state of Ohio. Mrs. Collins.
Thank you. May it please the court, Ms. Hockner, ladies and gentlemen of the jury. On September 20th of 2024, detectives with the Highland County Sheriff's Office and agents with the Highland County Task Force served a search warrant at the Fenner Ridge Apartments here in Hillsborough, Highland County. The residents of Fenner Ridge Apartment 3205 were Elizabeth Kibler and this defendant, Michael Carson. Now, during the search of the apartment, law enforcement found multiple containers of a crystal white substance throughout the apartment. These items were all sent to BCI, and they all tested positive for methamphetamine. The total weight of all the methamphetamine found that day in the apartment was over 20 grams. During this trial, you will hear from the officers that executed the search warrant, took pictures, and collected the evidence. You will hear from the chemist that analyzed the white substance and found that it was methamphetamine. He also weighed that substance. You will get to see the methamphetamine that was collected, the pictures of the search, and the BCI report that was completed showing that it was methamphetamine and the weights of the meth. You will learn from the court in the jury instructions that bulk amount of methamphetamine is 3 grams. So 5 times bulk amount would be 15 grams. This methamphetamine weighed 22 grams, so even greater than 5 times bulk amount. Finally, at the conclusion of this testimony, and after you review the evidence, I am confident that you will find Michael Carson guilty of aggravated possession of meth in an amount exceeding 5 times bulk amount, or more than 15 grams of meth. Thank you.
All right, thank you. Ms. Hapner, on behalf of the defense.
Thank you. Ladies and gentlemen of the jury, Judge Collins, Mrs. Collins. Mrs. Collins has outlined the state's theory of the case, but I want you to keep in mind a couple of things. A, it is the state's burden to prove beyond a reasonable doubt that this methamphetamine was in the possession of my client. But I also want you to keep in mind things that you will not hear. She's told you about the things that you will hear. I'm going to just give you a preview of things that you will not hear. You will not hear that Mr. Carson was married to Elizabeth Kibler. You will not hear any proof that Mr. Carson was a resident in this apartment. You will not hear that any drugs were found on his person. Keep those things in mind as you are deliberating this case and coming to your conclusion, because those are all important things. Evidence is not just what is presented, but it's also what is not presented. Thank you.
All right, thank you. Is there a separation?
Yes.
All right. Court orders that all witnesses be separated other than State's Representative, Mr. Angenor. All right, your first witness, Collins.
Stanton Whistler.
Mr. Whistler, this is being broadcast on YouTube. Do you have any objections to being shown? All right. Have you been sworn in the clerk's office? Have a seat right over there. If you have a cell phone, make sure it's on. And if you would pull that microphone over to your left in front of you. So, thank you. All right, you may inquire.
Thank you. Please state your name for the record.
Stanton Weisler.
And are you currently employed?
I am.
Where are you employed?
I'm employed at the Ohio Bureau of Criminal Investigation.
And what does the Ohio Bureau of Criminal Investigation do?
A few different things. The thing that I do is I work in the laboratory. Specifically, I test seized drugs to see if there are controlled substances present. There are other laboratory sections that do fingerprints, DNA, things like that. There's also a law enforcement side that's kind of like the state version of the FBI that might assist local agencies with more complicated investigations, or investigations like a lot of times we're involved with officer-involved shootings where maybe you don't want the Hillsborough Police Department investigating themselves on that, so they'd ask us to come and do that. And then we also do civilian identification, so if you're certain jobs, they want to do background checks, they run your fingerprints and see if you have a criminal record you're trying to hide.
How long have you been employed with BCI?
15 years.
And what sort of education, background education do you have?
Yeah, we'll stipulate to his credentials.
All right. Stipulated that he is an expert in this area. Go ahead.
In the area of forensic chemistry and weight, perfect. Does BCI have a written procedure manual for substance identification and measurement?
We do.
And do you follow that lab protocol when you do testing?
I do.
And when you receive an item into the lab for testing, what steps do you follow when you initially receive it?
I place it into my custody. We have an electronic custody tracking. Every single case that comes to BCI gets a unique BCI case number. Because we represent all the law enforcement agencies in Ohio, it's very possible the Hillsborough Police Department and the Highland County Sheriff's Office would both think 25-0001 is a great first case of the year starting number. So to make sure we don't have conflicts where we're using the same number to represent two different cases, we give each case its own BCI case number. Every piece of evidence gets barcoded, and then using those barcodes, we track custody electronically. So the first step, circuitously, put it in my custody, see what I have with visual examination, what I think I might have present, weigh the substance if appropriate, minus any packaging. So if the powder's in a plastic bag, you take it out of the plastic bag to weigh it. Preliminary color tests, if appropriate. In this case, I used the Marquis reagent, which is sulfuric acid and formaldehyde. It makes heroin turn purple. It makes methamphetamine turn orange. It makes some other drugs turn some interesting colors. And that's a good first step to make sure that your visual exam is matching your preliminary color tests. After that, I prepare a sample for instrumental analysis on a gas chromatograph mass spectrometer. I run that test, see what results I get, and then I write a report. After I'm done with the evidence, I seal it and return it in a temporary return location so that eventually when the law enforcement agency comes back dropping off more evidence for a different case, they can take their old evidence back with them.
And the testing that you just described, starting with the color test and then the gas thermometer test, is that the test that you used in this specific case?
Yes, it is.
And the report that you mentioned that you completed, did you complete a report in this case?
I did.
May I approach the witness?
You may.
You got a name who has previously been identified as State's Exhibit 1 for identification purposes. Do you recognize that?
I do.
And what is that?
This is the laboratory report I prepared in this case. I can tell because it's got the unique BCI case number corresponding to the case we're talking about today.
And that is a report that you complete, a similar report, every single time you do a test in a case?
Yes.
And can you tell from looking at that when the evidence was received by BCI?
It was submitted to us on December 12th, 2024.
I'm next going to hand you, would you like gloves? We're not going to take anything out.
If it's just this, no, thank you.
What's previously been marked as State's Exhibit 2 for identification.
Okay.
Do you recognize that?
I do.
And what is that?
This is item 1 on my report. I can tell it's got the BCI barcode with the unique case number 24-125954. Item 1, as you see, my initials here, including the date that I sealed this evidence, which was January 23rd, 2025, and that same unique BCI case number in my own handwriting, as well as the item number 1.
And that appears just to be a closed-up container. Is there a trick to this?
So this is a screw-top container, if I remember correctly. Inside of this, there is a plastic bag with crystalline solid substance. I know that from my report. I'm not immediately certain, but I believe this part disconnects from this part. If you want to open this specific item, you can, if that's of interest. But
so you can unscrew that. There is a bag of crystal substance inside of it.
Yes, that is correct.
And you completed a test on that crystal substance?
I did.
The same test that you described earlier in your testimony?
That is correct.
And according to the report, what was your, based on your expert opinion, based on your testing, education, and experience, what is the substance that's contained within State's Exhibit 2?
So State's Exhibit 2 was found to contain methamphetamine.
And did you determine if you were doing the testing properly?
I followed the procedures in our manual regarding how to test drugs.
And the tests, were they performed properly?
Yes, they were.
Now, when you weigh a substance, do you remove it from the bag before you weigh it?
I do. For example, in this item, I'll skip ahead to the answer. The answer is 2.60 grams, plus or minus 0.05 gram. This false grenade weighs significantly more than 2 grams, so going to absolutely tell with great confidence that it was done here, but that's what we always do. We take the substance out of the packaging it's in.
So you would have opened the grenade, taken the substance out, tested it, and then weighed it out of the grenade in the bag that it's in?
So the weighing will be the first step, because the chemical testing and the gas chromatograph testing, the GCMS, both consume a little bit of sample. The first thing I do is take a weight. So it's the weight of what I started with and not the weight after I've removed some to test it. But other than that, yes, it's been removed from the false grenade and from the plastic bag inside the false grenade.
And what did you do with State's Exhibit 2 after you tested it, or after you weighed it and tested it?
Sealed it back up, so the plastic bag is sealed. I put it back inside the grenade because the basic procedure is return it how you found it. So because it came in the grenade, I put it back in the grenade, sealed it back up here of the heat seal, and then I placed it back in that container sitting on that desk that I believe it was 6, wasn't it? Yeah, all 6 items I received started in that plastic bag and went back into that plastic bag.
Okay. Getting into has previously been marked as State's Exhibit 3 for identification purposes. Do you recognize that?
I do.
And what is that?
State's Exhibit 3 is my item 2, which tell it the same way, BCI barcode label, case information, case number, item number, my handwriting, initials, same case number, same item number. So that's how I recognize it.
And the testing measures, did you perform testing on State's Exhibit 2?
I did.
Or 3, rather, I'm sorry.
Sorry, State's Exhibit 3, my item 2. I tested that in the same way I tested State's Exhibit 2, my item 1.
And again, when you look at that, it just looks like a black container.
It does look like a black container. This one you can quite clearly see the zipper on it. You unzip it, there's stuff on the inside. And after I tested it, I put it back in there and zipped it back up. I returned it the way I found it.
And the stuff on the inside, is it a crystal substance?
It is.
And in your expert opinion, based on your testing education...
Excuse me, I think, is this one of your possible witnesses? One of these possible witnesses?
No.
Okay, all right, go ahead. Sorry.
In your expert opinion, based on your testing, education, and experience, what was the substance contained in State's Exhibit 3?
The substance was, again, methamphetamine.
And again, did you determine that you were doing the testing properly?
I did.
And when you weighed the substance, did you remove it from the bags that it was in?
Again, this metal hook alone weighs more than the weight I determined, which was 1.14 grams, plus or minus 0.05 gram.
And did you find that weight based on your testing, education, and experience?
Yes.
And again, what did you do with State's Exhibit 3 after you collected it?
Sealed it back up the way I found it, back inside the bag, heat seal initialed, and placed back in that larger plastic bag sitting on that desk.
I'm next going to hand you what's previously been marked as State's Exhibit 4 for identification purposes.
All right.
And what is that?
State's Exhibit 4 is my item 3. I can tell in the same way, BCI barcode, BCI case number, item number on this face, my initials, the date I sealed it, the BCI case number and item number in my own handwriting.
And the testing that you described earlier in your testimony, did you perform the same testing on this?
I did.
So, again, did you have to open that, take something out of it?
I opened it. I took a little bit out. The weight here is trace amount, so that is to the point where I would not have, dumping out everything I could, it would not have been over the minimum threshold we weigh in our balance. So we call that trace amount. But other than that, tested in the same way.
And in your expert opinion, based on your testing, education, and experience, what was the substance contained in State's Exhibit 3?
Methamphetamine again.
And did you determine that you were doing that substance or doing that testing properly?
I did.
And what did you do with that State's Exhibit? I'm sorry.
State's Exhibit 4.
4. Yes, I said 3. State's Exhibit 4. What did you do with that item after you tested it?
I closed the lid back on the metal container, sealed it in the same way, so that it can be returned to the agency.
And now State's Exhibit 5. Do you recognize this?
I do.
And what is that?
State's Exhibit 5 is my item number 4. I tell in the same way. BCI label with a case number and item number. my initials, the case number and item number, and here you can see that's a plastic bag containing crystalline substance. And yeah, it's better to see it this way. It's backwards, but I can see the same information backwards on this plastic bag inside the plastic bag.
And again, did you do the testing on this State's Exhibit 5 that you previously testified to?
I did.
And based on your expert opinion, based on your testing, education, and experience, what was the substance contained in State's Exhibit 5?
It was methamphetamine.
And again, did you determine that you were doing the testing properly?
I did.
And did you weigh State's Exhibit 5?
I did. It had a weight of 2.48 grams plus or minus 0.05 gram.
And what did you do with State's Exhibit 5 after you tested it?
Placed the crystalline substance back in this bag, sealed that bag, placed the bag inside the outer bag, sealed that bag, and then placed it in the larger plastic bag to be returned.
And State's Exhibit 6, do you recognize that?
I do. I apologize. We're moving on to the second page of State's Exhibit 1. I'm going to get page 1 out of my way. So State's Exhibit 6, I do recognize in the same manner. It is got the BCI label, BCI case number, BCI item number. See my initials and date on the seal, and the BCI case number and item number in my handwriting. And then as well, you can see onto the plastic bag inside there, you can also see my initials on the seal I made there, the BCI case number and item number.
And again, did you use the same testing methods that you previously testified to?
I did.
And in your expert opinion, based on your testing, education, and experience, what's the substance contained in State's Exhibit 6?
Methamphetamine.
And did you determine that you were doing the testing properly?
I did.
And in your expert opinion, based on your testing, education, and experience, what was the weight of the substance contained in State's Exhibit 6?
1.71 grams plus or minus 0.05 gram.
And what did you do with State's Exhibit 6 after you tested it?
Place the crystalline substance back in the plastic bag, seal the plastic bag, place the plastic bag in the larger plastic bag, seal the larger plastic bag, and placed it in that plastic bag yonder.
Okay. And State's Exhibit 7, do you recognize that?
I do.
And what do you know State's Exhibit 7 to be?
State's Exhibit 7 is my item 6 from this case. I can tell it's the same way we've talked about several times. BCI item label, case number, item number, case number and item number in my handwriting, and then date I sealed it, case number and item number.
And did you use the same testing methods that you previously testified about?
I did.
And in your expert opinion, based on your testing, education, and experience, what is the substance contained in State's Exhibit 7?
It is again methamphetamine.
And did you determine that you performed the testing properly?
I did.
And did you also weigh the substance?
I did.
Did you again remove it from all the packaging before you weighed it?
I did.
And in your expert opinion, based on your testing, education, and experience, what was the weight of State's Exhibit 7?
14.09 grams plus or minus 0.05 gram.
And again, what did you do with State's Exhibit 7 after you tested it?
Placed it back in the bags that came in, sealed those bags, and then sealed the outer bag and placed it in that larger plastic bag on the prosecutor's desk.
My last question, Mr. Wiesler, what is the total weight of State's Exhibits 2 through 7? Can you tell that from the report?
Not off the top of my head without a calculator. I know that a relevant statutory amount of methamphetamine is between 15 and 150 grams. Sorry.
The question was whether he knew the total weight, and he said not without a calculator. Then he went on to something else, just non-responsive at this point.
Well, actually, I think it is responsive, so I'll overrule the objection.
So it's going to be statutorily relevant, but there's more than 15 and less than 150 grams, which is more than 5 times the bulk amount of methamphetamine, less than 50 times the bulk amount. And then the 14.09 grams, I round that to 14. And I take item 1, round that 2.6 down to 2. 14 plus 2 is 16. So we're over 15. And then eyeballing this, none of these numbers are going to get us close to 150. So we're more than 15 grams, less than 150 grams. Without a calculator, I don't have the exact number handy.
Fair enough. I have no further questions, John.
Cross.
Thank you, Your Honor. Mr. Wiesler, you do all of your work there in the lab at BCI.
That's correct.
So you're not involved in the collecting of this evidence?
That is correct.
And you don't have any idea where it came from other than that it arrived at the PCI from the Sheriff's Department.
That is correct.
And you don't have any contact with the law enforcement or the defendants in this case.
That is correct.
And so you don't have any way of knowing who this substance may have belonged to.
That is correct.
No further questions, Your Honor.
Redirect.
No, no, Your Honor.
All right, you may step down.
Thank you.
Next witness.
Captain Chris Bowen.
While you're getting him, would you come, counsel approach, please? All right, Christopher Bowen, please. Did you get sworn in at clerk's office? And do you wish to be shown on video? Okay. Have a seat, sir. All right, you may inquire.
Please state your name for the record.
Chris Bowen.
Are you currently employed?
Yes, I am.
Where are you employed?
At the Highland County Sheriff's Office.
How long have you been employed in law enforcement?
31 years, 9 months.
And what are your job duties at the Sheriff's Office?
At the Sheriff's Office, I currently do administrative work. I assist with investigations, and I oversee the task force.
So are you also assigned to the Highland County Task Force?
Yes.
And were you employed at the Sheriff's Office or assigned to task force on September 20th and 24th?
Yes, I was.
And on that day, were you requested to assist with a search warrant?
Yes, I was.
What was the address of the search warrant?
148 Fenner Avenue, building 138, apartment 3205.
And what county is that in?
Highland County.
Is that here in Hillsborough?
Yes, it is.
What was your role that day of the search warrant?
I assisted with a search of a bedroom. I took photographs, and I collected some of the evidence.
Into was previously been marked as State's Exhibit 8 for identification purposes. Do you recognize that?
Yes, this is a photograph of the bedroom.
I'm next going to hand was previously been marked as State's Exhibit 9. Do you recognize that?
Yes, this is a photograph inside the bedroom that just shows the end of the bed.
And State's Exhibit 10. Do you recognize that?
Yes, this is a photograph taken also inside the bedroom. Shows the right side of the bed, a nightstand with a Purple Heart.
State's Exhibit 11.
This is also a photograph of a nightstand taken in the same bedroom on the left side of the bedroom.
State's Exhibit 12.
This is a photograph in the bedroom of a black or a gray duffel bag that was sitting on the floor on the left side of the bed.
And State's Exhibit 13.
This is a photograph of court documents. It's an assignment notice in the name of Michael Carson. This was also located on the nightstand in the bedroom on the left side of the bed.
When you came into the bedroom, did you locate a pile of stuff on the bed?
Yes, I did.
And were you advised by law enforcement where that pile of stuff came from?
Yes, I was.
And where?
I'm going to object that it's hearsay, Your Honor.
Not from the truth of the matter, certainly did.
Right, he's only explain what he did. Okay, it's overruled, submitted for that purpose only.
You can continue.
Yes, I was informed by Lieutenant Seaman that the items laying on the bed had came from some gray shorts that were on the floor beside the bed on the left side of the bed.
Based on that, did you search the items, search through the items?
Yes, I did.
Next thing I think you was previously been marked as State's Exhibit 14 for identification purposes. Do you recognize that?
Yeah, this is a photograph of the contents that came from the shorts on the floor that was laying in the bed where I found them.
State's Exhibit 15. Do you recognize this?
Yes, this is a photograph of some of the contents from the shorts, and also there's a camouflage container in this photograph, and there's a grenade keychain in the photograph. that came from the shorts on the floor.
State's Exhibit 20. Do you recognize this?
Yes, this is a photograph of the grenade that was laying on the bed with the top that was taken off of it, and then an additional photograph was taken of it to show the contents, which was a plastic baggie that contained meth.
I'm next going to hand you what's previously been marked as State's Exhibit 2. Do you recognize this?
Yes, this is the actual grenade that was located on the bed that contained methamphetamine.
So that thing opens up somehow?
Yes, the top of it will just screw off. The top screws off, and the inside is hollow, and that's where the meth was located.
Let's go back to State's Exhibit 15. What are you holding in your fingers there in that picture?
A little camouflage vial. The top came off of it, and there was also methamphetamine inside it.
Next thing you was previously been marked as State's Exhibit 16 for identification purposes. Do you recognize that?
This is a photograph of me holding the camouflage vial and the lid's off of it, and you could see inside it.
And State's Exhibit 17?
This is a close-up of the same vial, and it shows the residue around the top of it.
I'm next going to hand you what's previously been marked as State's Exhibit 4 for identification purposes. Do you recognize that?
Yes, this is the little camouflage vial that I just testified to.
And State's Exhibit 18. Do you recognize that?
Yes, this is a black pouch that contained a plastic bag of white powder that was also laying on the bed with the items that came from the shorts.
State's Exhibit 19. Do you recognize that?
This is a different photograph of the same black pouch opened up with that shows the plastic bag inside the pouch as I found it.
And State's Exhibit 3. Do you recognize that?
Yes, State's Exhibit 3 is the pouch.
I'm next going to hand you what's previously been marked as State's Exhibit 21 for identification purposes. Do you recognize this?
Yes, this is the gray duffel bag that was located on the floor beside the bed, and I started to unzip it, and I began taking pictures of the contents inside.
State's Exhibit 22. Do you recognize that?
Yes, this is just another picture of the duffel bag that, once I opened it up, contained some drug paraphernalia and some digital scales.
State's Exhibit 23. Do you recognize that?
Just photographs of the paraphernalia from inside the pouch, or duffel bag.
State's Exhibit 24.
I'm going to object at this point, Your Honor. May we approach?
Okay. All right.
State's Exhibit 24. Do you recognize that?
Yes, this is a photograph of some mail that was addressed to the defendant that was in the gray duffel bag.
State's Exhibit 25.
Yes, this is a red pouch that came from within the duffel bag.
State's Exhibit 26, do you recognize that?
Red pouch that contained digital scales.
State's Exhibit 27, do you recognize that?
A photograph of the digital scales once I took the top off of it.
Lieutenant Bowen, or I'm sorry, Captain Bowen, do you have experience with the use of scales like that in drug cases?
Yes.
And what is the common use for scales like that?
The scales are used for weighing dope, for weighing out the dope so that they know exact amount that they're possessing or selling or whatever they're doing with it.
And our state's exhibits 8 through 27, the pictures that you just testified to, are those true and accurate depictions of the things that you located in the bedroom that day?
Yes.
Let's go back to state's exhibit 27. There are some cards in that picture. Where did those cards come from?
Those cards were in a box on the nightstand with Michael Carson's name on them.
And upon recovering state's exhibits 2, 3, and 4, the physical items that you testified to, what did you do with those?
I turned those over to Lieutenant Antonor.
And Captain Bowen, how long have you been assigned to the Highland County Task Force?
Can you repeat? I couldn't hear you. I'm sorry.
How long have you been assigned to the Highland County Task Force?
Approximately 3.5, 4 years now.
How many drug cases over your 30-plus year career have you investigated?
Approximately 1,000.
And do you commonly see drugs in the plastic bags that you found in this case?
Yes.
Do you send those plastic bags to BCI to be fingerprinted?
No, I do not.
Why not?
BCI, in my experience with BCI will not fingerprint baggies that contain drugs in it. The prints are extremely difficult to lift off of there, and it's quite honest, it's a little bit on the dangerous side to try to do that.
Do you send any of these items to BCI to be DNA tested?
No, BCI will not DNA test on drug cases.
You said it's a little bit dangerous to try to lift prints off these. Why is it dangerous?
If you put tape on the bags and the bag rips, and then you got to worry about the contents inside the bag spewing out, and honestly, you don't know what type of different drugs are in that drug.
I have no further questions, Your Honor.
Ross?
Thank you, Your Honor. Lieutenant Bowen, did you take these photographs yourself?
Yes, I took some of the photographs. I did not take all of them.
Okay, can you tell us specifically which ones you did take?
The photographs of the evidence that I collected.
Okay, well, so we've got photographs, exhibits 8 through 27. Which of those photographs did you take and which did you not take?
I would have to see something to refresh my memory on what I took. I took photographs of the bedroom of the exhibits that I testified to, and then I took photographs of items that I collected.
But you don't recall specifically which of this stack of photographs you took?
Not without you showing me. No, I do not. I don't know what's in your stack of photographs.
Well, may I approach, Your Honor?
You may.
My stack of photographs are the exhibits to which you just testified, right here.
Okay.
So this is Exhibit 8. Did you take that?
Exhibit 8. I believe so, yes.
Exhibit 9. I should. I said that way too.
Yes, I believe so.
Exhibit 10.
Yes, I believe so.
Exhibit 11.
Yes.
I'm not sure what's up there. Exhibit 12. I don't think your motion looks like that's how I agree.
Yes. That's the way it's supposed to be. This is sitting on the floor. That's the bed.
Okay. Exhibit 13.
Yes.
Exhibit 14.
Yes.
Exhibit 15.
Yes.
Your Honor, I'm going to object to the relevance.
No overrule.
Exhibit 16,
Yes.
exhibit 17.
I believe so.
Exhibit 18.
Yeah, I believe so, yes.
19.
I believe so, yes.
20.
Yes.
21.
I believe so, yes.
22.
I believe so.
23.
I believe so, yes.
24.
I believe so, yes.
25.
Yes.
26.
Yes.
And 27.
Yes, I believe so.
Those are your comments.
So, in several of these photos, there is a hand with a blue latex glove or plastic glove.
In some of the photographs, yes.
Whose hand is that?
If I took the picture, it would be my hand.
So you're holding evidence in one hand and taking the photo with the other.
Yes, ma'am.
Okay. Was that awkward?
Do it every day.
Now, you testified to these scales that, in your experience, scales like this are used to weigh drugs.
That's correct.
But scales have other uses too, don't they?
Oh, I'm sure they do, yes.
I mean, I've got scales in my office.
Objection.
I was sustaining the formal question.
Okay. So scales are used in businesses to weigh letters to know how much postage to put on. Is that correct?
That's correct.
Pharmacies use scales to weigh out prescription medication. Is that correct?
Yes, that would be correct.
This backpack, this gray backpack, where was that located?
That was on the floor beside the bed on the left side. So when you walk in the door, make a left, walk to the end of the bed, look straight ahead. It was sitting there on the floor.
Did you look through the closets?
I did not.
To your knowledge, did another deputy?
To my knowledge, the whole room was searched, yes.
Okay, but you're not sure who would have done that?
No, ma'am.
Was your search limited to, and I don't want to put words in your mouth, so please correct me if I'm wrong, was your search limited to the items in the backpack and the items on the bed?
My search was that side of the bed, period. If it was on that side of the bed, I searched it.
Okay. So if it was on the other side of the bed, you had nothing to do with it?
Correct.
I have no further questions, Your Honor.
Redirect.
Just if you have knowledge, Mr. Captain Bowen, is Michael Carson a pharmacist?
No, he is not.
Are the exhibits, the pictures 8 through 27, are those true and accurate depictions of the scene as they appeared that day?
Absolutely, 100%.
I have no further questions.
All right, you may step down. Next witness.
Lieutenant Vincent Antoine.
Were you sworn in downstairs? Would you raise your right hand, please? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
See there. Pull the mic over, please. Name quiet.
Thank you. Please state your name for the record.
I'm Lieutenant Vincent Antonor of the Highland County Sheriff's Office.
How long have you worked at the Sheriff's Office?
I've been there 14 plus years probably.
And what are your job duties there at the Sheriff's Office?
Currently, I'm a lieutenant. I work every day in our detectives division as I supervise that unit, as well as a couple other units there that I supervise.
And were you employed there on September the 20th of 2024?
I was.
And on that day, were you requested to assist with a search warrant?
Correct.
And what was the address of the search warrant?
148 Fenner Avenue, Building 138, Apartment 3205.
What county is that in?
It's in Highland County.
Is it here in Hillsborough?
It is.
And what was your role that day of the search warrant?
So I had multiple roles that day. First off, I prepared the search warrant, went to the apartment, conducted surveillance, knocked on the door, made initial contact, entered the apartment, searched the apartment, that sort of thing.
When you entered the apartment, who was located in the apartment?
Well, before we entered, as the case with most search warrants, we don't just like kick in the doors like you see on TV. We knocked on the door. Elizabeth Kibler, a known resident of the apartment, came out. We had a discussion with her with why we were there, what our intention was. At that time, we asked her if anybody else was inside. I personally talked to her. She informed me that she lived with Michael Carson. He was inside in bed asleep.
I'll sustain that.
Move to strike
Okay, stricken.
and ask the jury to disregard.
They will. I'll tell them at the end of the case. But yes, you're to disregard.
Based on what she told you, what did you do?
So we entered the apartment, and, well, prior to entering the apartment, I guess, we, again, announced our presence, opened the door, located Mr. Carson lying in bed asleep. At that point, we had not made entrance into the apartment. We were using a shield as cover and giving verbal commands to have him come out to us. Mr. Carson said that he was in bed and that he was in his underwear and asked if he could get dressed and put his shorts on.
Do you see Michael Carson, the person that you found in bed that morning here in the courtroom?
I do.
And where do you see him?
He's at the defense table in a blue shirt.
Please let the record reflect the witnesses identify the defendant.
So ordered.
And yet, you mentioned being in underwear and shorts. Where were the shorts located?
So he was in bed in his underwear. The shorts were located directly next to the bed at the bedside in front of the nightstand.
And did you allow him to put those shorts on?
Not immediately. So at that time, I instructed Lieutenant Seaman to enter the apartment, which I observed him do while communicating with Mr. Carson. He emptied the shorts for all of its contents and then allowed Mr. Carson to get dressed and escorted him out to us.
Where did he empty those shorts at?
Onto the bed and the floor next to the bed. I think a couple items may have fell.
I'm going to hand you what's previously been marked as State's Exhibit 14 for identification purposes. Do you recognize that?
I do.
And what is that?
That is some of the contents that was in Mr. Carson's shorts.
I'm next to, during the search warrant, did you also take pictures and collect evidence?
I did.
I'm next going to hand you what's previously been marked as State's Exhibit 28 for identification purposes. Do you recognize that?
I do.
And what is that?
So this is a photo I took of a bag and some contents that was next to the bed.
And State's Exhibit 29. Do you recognize that?
I do.
And what is that?
So this is the cigarette pack that was located here next to the bed with this wallet.
And State's Exhibit 30. Do you recognize that?
I do. That is a clear plastic bag containing what was later identified as methamphetamine inside the cigarette pack. It was removed from the cigarette pack for purposes of the photo.
And State's Exhibit 5. Do you recognize that?
I do. That is the actual bag that you see in this photo.
Okay. Next, going to hand you what's previously been marked as State's Exhibit 31. Do you recognize that?
I do.
And what is that?
This is a nightstand next to the bed inside the bedroom Mr. Carson was removed from.
Okay. State's Exhibit 6. Do you recognize this?
I do.
And what is that?
This is the baggie containing what was later identified as methamphetamine that you see here on the nightstand in the photo.
Okay, skip this one. States Exhibit 32. Do you recognize that?
I do. It's a close-up of the baggie that you see in the prior photo.
Next getting into what's previously been marked as States Exhibit 33. Do you recognize that?
I do. It's a box of tissues that was also on that nightstand.
And States Exhibit 34. Do you recognize that?
I do. That is a picture down inside the same tissue box that if you were to remove the tissues, there was a container and some what was later identified as methamphetamine hidden inside the tissue box.
And States Exhibit 35. Do you recognize that?
I do. That was the blue container and the methamphetamine that was located inside the tissue box.
States Exhibit 7. Do you recognize this?
I do. That is the blue container and the methamphetamine that was in that prior picture that was removed from the tissue box in the bedroom.
States Exhibits 28 through 35. Are those true and accurate depictions of the scene as they appeared that day?
They are.
I'm going to go back to States Exhibit 8. Do you recognize that?
I do.
And what is that?
This is a photo of the bedroom Mr. Carson was removed from and that we searched during the process of the search warrant that this methamphetamine was located in.
And the items that were found in his shorts, where on the bed did you place those items, or were those items placed?
Lieutenant Seaman just placed them. You can kind of see here on the side of the bed where Mr. Carson was laying, where he got up. That's where the items were placed.
And how far from where Mr. Carson was laying was States Exhibit 7?
I don't know, maybe 4 feet on the nightstand.
Now, after recovering States Exhibits 5, 6, and 7, what did you do with those items?
They were packaged, inventoried, and placed in our evidence room at the sheriff's office, where they were later transported to BCI.
Did you send any of these items, or when they went to BCI, did you ask BCI to fingerprint any of these items?
No, we did not.
Why not?
It's not something we routinely do. It's inherently dangerous. It's incredibly unsuccessful and just at risk to the people that would be involved in the testing process, including ourselves.
Why is it inherently dangerous to yourself?
The drugs are dangerous. That's why we target them, whether it's methamphetamine or any other controlled substance. It's not something you want to handle. You see in the photos we're wearing gloves. That's not because we want to. It's because they're dangerous, and we don't want to expose to those drugs. Anytime you put tape to lift a fingerprint on a baggie, you take the chance of getting that drug on the tape that we're later going to handle and not know that there's drugs on it.
Did you ask BCI to DNA test any of these items?
It's not something we would do because BCI doesn't do DNA testing on routine drug cases.
Did you search other parts of the bedroom?
Yes,
Did you search the closet?
I did.
Did you find clothing there that belonged to a man?
I did.
I have no further questions.
Cross.
Thank you, Your Honor. You testified that you found Exhibit 7, the blue container, about 4 feet from where Mr. Carson was sleeping. He was on the other side of the bed, was he not?
Where he was sleeping at? I believe he was in the bed, yes.
Correct, but you found the blue container in a tissue box on the other side of the bed.
It was on a nightstand on the opposite side from where he was sleeping, yes.
Okay. Now, if you'll take a look at Exhibit 28, please. Do you have that in front of you?
I don't. I can search through here and try to find it if you'd
Okay,
like.
I got my copy. Be happy. May I approach you? May I?
Yes, you may.
All right, so this is, you testified this is good mark as Exhibit 28. Is that familiar to you?
The photo is familiar. If it would be okay, I'd prefer to get State's Exhibit 28 just to make sure it's the same photo. Is that okay? Can you see that here? Oh, there it is. Okay.
So there are lots of things in this photo.
Oh, there's several things in the photo, yes.
And there's some prescription pill bottles.
Correct.
See this? Do you recall who those were labeled to?
I believe Elizabeth Kibler.
And there's a wallet with a driver's license. Is that correct?
Correct.
And whose driver's license is that?
I believe Elizabeth Kibler's.
And then it looks like there's a gas bill. Do you see that in the photograph?
I do.
And do you recall who that gas bill was directed to?
I do not recall.
Fair enough. There's also in this photograph the cigarette packet, correct?
That is correct, yes.
And then your next photo, Exhibit 29, that's a close-up of that cigarette packet, correct?
That is correct, yes.
And that, is that the same cigarette packet that was found that was depicted in Exhibit 28?
It is, yes.
And once again, in the back, we have Elizabeth Kibler's wallet, her driver's license.
Yes, that is correct.
And did this, the wallet and the cigarette packet, did that come from the same place? Let me ask you this, where did you find those?
They were next to the bed here on this side of the room, yes.
Okay, on the opposite side from where Mr. Carson was sleeping.
Were those located on the opposite side?
Correct.
Yes, that is correct.
Okay. Located on the same side as the nightstand that had the tissue box that had the blue bag that had the large amount of methamphetamine in it. All the same, that was all the stuff was on the same side of the bed.
Yes, that is correct.
Okay. I'll get to this at some point today.
Did you check with the property owner or the manager about who leased that apartment?
I did.
And did you find out who leased that apartment?
I did. So the property manager was on scene that day. They stated that they were having problems with the tenant because it was leased to Elizabeth Kibler. However, she had Michael Carson living with her.
So it's not leased to Michael Carson.
Correct.
Okay. Did you inquire whether there is a provision in the lease that for no overnight guests or no overnight guests for more than a certain number of days?
I did not.
What time did you first arrive at the apartment?
For the search warrant?
No, my question is, that day, what time did you first arrive at that apartment?
I don't know the time for certain.
Did you have the search warrant in hand when you arrived?
We did not.
Did you speak to Ms. Kibler and Mr. Carson prior to receiving a search warrant?
That is correct, yes.
And you testified about having him come out of the apartment. Was that prior to getting a search warrant?
That is correct, yes.
Okay. So at the time that you told him let me ask this, at the time that the items were removed from his shorts, there was no search warrant. Is that correct?
That is correct, yes.
Okay. And how long was it from the time that you first spoke with Mr. Carson until you obtained a search warrant?
I don't know time for certain. The purpose of speaking with Mr. Carson at the time was to preserve evidence and have him come out of the apartment.
Okay. Was that 5 minutes, 2 hours, 12 hours?
I don't know for certain.
You didn't keep a log of that.
I did not.
Would it surprise you to find that it was a couple of hours?
No, that's pretty typical. A judge has to sign our search warrants, and typically we're at the mercy of whenever a judge is available to review it, sign it, and send it back to us. If it was up to me, it would certainly be a lot quicker.
So when you first knocked on the door of the apartment and asked Mr. Carson and Ms. Kibler to speak with you, you had no search warrant?
I did not ask Mr. Carson to speak with us when we knocked on the door.
You asked Ms. Kibler to?
Correct.
And you had no search warrant at that point in time?
That is correct.
No further questions, Your Honor.
Read record.
All the items that were testified to, were those all located in the bedroom?
They were.
And who was located in the bedroom?
Mr. Carson.
Were there other indications other than male's clothing that Mr. Carson was staying in that room?
Yes, just as I spoke to a minute ago, the property manager even told us that Mr. Carson lived there with Ms. Kibler.
I'm going to object to that, Your Honor.
That was a question that was answered when she
I'm going to
asked.
strike the hearsay.
Thank you.
Jury disregarded.
I have no further questions.
Why don't you step down? Well, counsel, would you approach? All right, ladies and gentlemen, that's completes the evidence. The state is going to rest. So I'm going to have you take an early lunch. It's only 11. We've done about 11:05. I want you to come back at 12:15, and then we expect to be proceeding with closing arguments, instructions of the court at that time. So that it looks like you probably will have the case to deliberate maybe around 2 o'clock. You may go ahead and leave the building, go to lunch during the break. Remember all the instructions of the court not to discuss the matter with anyone, even among yourselves. Don't look up anything, listen to anything on the radio or TV. If there is anything, don't do any social media research on any topic that you've heard about in a case, and don't discuss the matter with anyone else or permitted to be discussed in the presence. And again, don't discuss it among yourselves. So if you would go ahead and leave, and we're going to stay here because we have to do a couple of things regarding some legal matters. We'll be back in the jury room by 12:15. Thank you. Now, as I understand, that's the last of the state's witnesses.
We would move to admit exhibits 1 through 35.
All right, are there any objections?
I would object to exhibits 8 through 27. Those are the ones that Captain Bowen was not positive that he actually took.
That's not the standard of proof.
Well, it doesn't have to take him, but I believe after you cross-examined him, he said he either answered affirmatively or I believe so to all of them, and he also testified that he was at the scene and it was fair and accurate, and so the person that identifies the photo doesn't have to be the person who took it.
That's fine.
So that is overruled. Any other objections?
No objections to the others.
All right, then the court will admit all of the exhibits. All right, state rest.
Yes.
What's happening?
We rest and we would move forward under Rule 29 that the state has failed to make a prima facie case. They have not been able to prove that Mr. Carson was actually a resident of that apartment and that any of these drugs were found on him or belonged to him, were possessed by him. At most, the ones in the grenade shape and the ones from the floor, but those are certainly do not rise to the level of an F2.
Ms. Collins?
I believe that there is no requirement in the law that we prove he was a resident. So I don't think that that is grounds to for Rule 29. I believe that jurors or people could come to different conclusions based on the evidence, and that is the definition of when a jury should get a case. So based on all of that, I would ask the court to overrule and deny the Rule 29 motion.
Is there anything else?
I would point out, just for purposes that it seems a little unfair to a defendant to tell them they don't have standing to make a motion to suppress because they're not a resident of the apartment, but then turn around and say, well, you don't have to be a resident to have possession of these drugs. So it seems a bit of a double standard there. We would just renew our motion.
Well, it's a conundrum, isn't it?
It is.
Unfortunately, the law's against you. So, all right. So the court will admit all of the exhibits and deny the Rule 29. All right. Now, are you going to present any of this?
We are not.
All right. Then I did draft the jury instructions, and I had prepared in anticipation there may be a testimony from the co-defendant, so starting at the bottom of page 2, the accomplice testimony, that'll be stricken out up to the part about experts, which generally, and I haven't reread this for cut and paste errors. I'll look at it during the lunch hour, but if either of you find anything, let me know.
I have stuff.
Pardon me?
I have things.
All right, tell me.
Page 5,
Okay.
law count 1, the second paragraph. There is a period between methamphetamine and under, and that shouldn't be there.
Let's see, wait a minute now. What is it?
Page 5.
Yeah, I've got it. What is it?
There's a period between methamphetamine and under that should not be there.
Oh, okay. Yeah. All right.
Page 8. I'm not sure if it's correct or not, but is the first paragraph where it starts with to find that an individual,
At the top of the page?
the first paragraph, that where it starts to find that an individual constructively possessed an item.
Yeah.
Okay, should there be a comma at the end of possession, or is that a new sentence? Because I thought that was the same sentence in prior OJI instructions.
Are you referring to the sentence that reads, to find an individual constructively possessed an item
Yes.
conscious of the presence of the object, although a defendant's mere proximity is in itself insufficient? No, that's a complete sentence.
Okay, I'm just saying that I think in other instructions there's been a comma there
Oh,
instead of a period. And
you mean at the end of construction or possession?
Yes.
Well, it is a period. I mean, because the next sentence is a different sentence, proximity.
I know there's a period, Judge. I'm saying that in other instructions I believe that it has been a comma, not a period. Because in the book it says, like in the law, that is a comma.
In the instructions, you mean?
Yes.
Okay.
Although a defendant's
I'll
mere
look at
proxy.
it.
Yeah.
Yeah. It's an awful long sentence. I may have just decided to make it simpler, but okay.
Page 9, additional finding if verdict is guilty or exceeding bulk amount B.
Okay. What's the comment? Okay. Less than bulk amount, equal to or exceeding, but less than 5 times, or equal to or exceeding 5 times bulk. Oh, but less than 50 times, right?
Right.
Yeah, there's just an extraneous letter hanging out there.
Yeah.
B. Yeah. Beach.
Equal to or exceeding 5 times bulk amount, but less than 50. That's what we have, right?
May I approach you, Sherry?
Less bulk, over bulk, less than 5 times bulk, 5 times or less than 50. Yeah, I know where we're at.
Okay.
I left out the less than 50. That's what you're getting to, right?
Yes.
Yeah, okay. Yep.
That's all I found. That's all the
Okay.
clear I got.
Yeah, in a jury, later under verdict forms, when the part there, I numbered them so I would keep myself straight. So I'll make sure that I do that in the book, in the text. Yeah, I also need to put a bracket there, or parentheses, not a bracket, bracket after bulk amount, 50 times bulk amount on page 11, I see. All right, anything else?
Yeah.
All right.
I think that anything else.
Any requests for any additional instructions from either side?
Can I have just a moment to discuss that with my client?
Sure.
Yeah. We're fine.
All right, then be back at 12:15. Thanks.
Please rise.
Before we bring a jury in, Rebecca Record case, State of Ohio versus Michael L. Carson. I handed up the revised jury instructions. I took a look at that grammar issue. The last one I gave was exactly this way. I couldn't get into the jury instructions. They said it damn for some reason. So, but it's just a grammatical error or issue, so I don't see there's any big deal about it. And then I do have a verdict form here if the council wants to take a look at it before we bring the jury in. It's a little cumbersome as to the additional finding if there's a guilty finding. So what I'm going to do, I'll give them a little more explanation than normally I do. But if you want to take a look at that, counsel, and explain to them they'll need to strike out the ones that aren't applicable.
On page 8 of the final verdict instructions you just gave us, there is a word missing.
Where is that?
On page 8.
Page 8, okay.
5 times. It just says 5 bulk amount. So it should, I think there should be 5 times.
Wait a minute. Okay, we got less than bulk amount, equal to or exceeding bulk, or less than 5 times bulk amount, or equal to or exceeding 5 times. Okay,
Yeah.
all right. All right. Okay, any objections to the verdict form?
Yeah, the verdict form has the wrong statute in it.
Oh, okay.
It's not,
292511.
It's not what you have.
Oh, okay, yep. 925.11. All right, I'll make that change. And it's also count 1. When I cut and pasted, I didn't get that change. Okay. All right, so 2 changes there. All right, now anything further before we bring the jury back in? All right. Go ahead and bring the jury in, please. Oh, she's not back. You be seated. All right, we're back on record. State versus Michael L. Carson. All right, during the break for lunch, we dealt with several matters. The state rested. The court admitted all of the exhibits that were identified in the record. The defendant is not presenting any evidence, and so we're now going to the instructions from the court. Then you'll hear the closing arguments of counsel, some final instructions on deliberation, and then you'll deliberate this afternoon as to the verdict. All right, ladies and gentlemen, you have heard the evidence. It is now the duty of the court to instruct you on the law. The court and the jury have separate functions. You decide the disputed facts, and the court provides instructions of law. Now, as indicated earlier, ladies and gentlemen, it's your duty, sworn duty, to accept these instructions and to apply the laws that is given to you. You are not permitted to change the law or to apply your own conception of what you think the law should be. All criminal cases begin with the filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The defendant entered a plea of not guilty, which is a denial of the charges and puts in issue all essential element of the offense. The defendant is presumed innocent until his guilt is established by proof beyond a reasonable doubt. Now, the defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the indictment. Now, reasonable doubt is present when jurors, after they have carefully considered and compared all the evidence, cannot say they are firmly convinced of the truth of the charge. It's a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of that person's own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You will apply the tests of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand, their manner of testifying, the reasonableness of their testimony, the opportunity they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest and bias, if any, together with all of the facts and circumstances surrounding their testimony. Applying these tests, you'll assign to the testimony of each witness such weight as you deem proper. And you're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You will determine what testimony is worthy of belief and what testimony is not worthy of belief. Now, each witness was subject to direct examination by the party who called them and to cross-examination by the opposite party. During the trial, counsel wasn't able to impart in some matters, did not relate directly to issues before the court. Such questions and answers are permitted for purpose of helping you to determine the credibility and the weight that would be given in their testimony for no other purpose. Now, generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. However, as with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. In determining its weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. It's not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not be considered for any purpose. Now, ladies and gentlemen, evidence is all of the testimony that was received from the witnesses and any exhibits the court has submitted into evidence during the trial. Evidence may be either direct or may be circumstantial, or may be both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which they testify. It includes, of course, exhibits admitted into evidence during that trial. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts which you may but are not required to make from the other facts which you have found have been established by direct evidence. Whether an inference is made rests entirely with you. In considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. So in other words, you cannot stack one inference upon another inference to reach a factual conclusion. Now, where the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence and convinces you beyond a reasonable doubt that the defendant is guilty. The evidence does not include the indictment, the opening statements, or closing arguments of counsel. Opening statements and the closing arguments, which you will hear here in a few minutes, as I've indicated previously, are designed to assist you. They are not evidence. Any statements that may have been stricken by the court that you were told to disregard are not evidence and must be treated as though you never heard them. You must not speculate why the court sustained any objection to any question or what the answer to that question may have been. You must not draw any inference or speculate on the truth of any suggestion that might have been included in a question that was not answered. And as I indicated previously, you disregard any answers that were stricken. Now, a number of exhibits have been introduced, and testimony relating to them has been introduced and admitted into evidence. You may consider whether those exhibits are the same objects, the same conditions they were originally, and you will determine what weight, if any, the exhibit should receive in light of all of the evidence. Now, the law under which the defendant is charged in count 1 is entitled aggravated possession of methamphetamine and is numbered Revised Code Section 2925.11. This law states in pertinent part as follows. No person shall knowingly obtain, possess, or use a controlled substance. Defendant is charged in count 1 with aggravated possession of methamphetamine under that section. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about September 20, 2024 in Highland County, Ohio, the defendant knowingly obtained, possessed, or used methamphetamine, a Schedule II controlled substance. Now, the essential elements of the crime of aggravated possession of methamphetamine as charged in count 1 of the indictment are as follows. That the defendant did 1, knowingly, 2, obtain, possess, or use, 3, methamphetamine, except the Schedule II controlled substance, and 4, the offense occurred in Highland County on or about the date alleged in the indictment. It's not necessary the state prove the offense was committed on the exact day as charged in the indictment, sufficient to prove the offense took place on a date reasonably near the date planned. Before you can decide whether the state of Ohio has proved beyond a reasonable doubt all of the essential elements of the offense for which the defendant is charged, you must first decide whether this is the correct county in which this trial should be held. The state must prove beyond a reasonable doubt that all or any part of the offense charged was committed in Highland County, Ohio. Now, a person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. The person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge may be established if a person is subjectively believes there's a high probability of its existence and fails to make any inquiry or acts with a conspicuous purpose to avoid learning the fact. Since you cannot look into the mind of another, knowledge is determined from all of the facts and circumstances and evidence. You'll determine from the facts and circumstances whether there existed at the time in the mind of the defendant awareness of the probability of the defendant's actions would cause a certain result or be of a certain nature. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. Where an act is a crime, a good motive or purpose is not an offense. The possession of methamphetamine is an essential element of the offense of aggravated possession of methamphetamine. Possess or possession means having control over a thing or substance, but may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises upon which the thing or substance is found. Possession is a voluntary act if the possessor knowingly procured or received the item or was aware of his control thereof for a sufficient period of time to have ended his possession. The person has possession when he knows he has the object on or about his person or places that were accessible to his use or direction, and he has the ability to direct or control its use. Possession may be constructive. Constructive possession exists when an individual is able to exercise dominion or control over an item, even if the individual does not have the item within his immediate control. Dominion or control may be established by circumstantial evidence alone. To find that an individual constructively possessed an item, the evidence must also demonstrate that the individual was conscious of the presence of the object, although a defendant's mere proximity is in itself insufficient to establish constructive possession. Proximity to the object may constitute some evidence of constructive possession. Thus, the presence of the individual in the vicinity of the item, coupled with other facts probative of dominion and control, may establish constructive possession. Two or more persons may have possession if together they have the ability to control it exclusive of others. Ownership is not necessary. A person may possess or control property belonging to another. Now, various chemical compounds subject to government control are called controlled substances and are placed in various categories or schedules by the Ohio Revised Code. Methamphetamine is a Schedule II controlled substance. Now, if you find that the state proved beyond a reasonable doubt all the essential elements of the offense charged in count 1 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense charged in count 1 of the indictment, your verdict must be not guilty as to such offense according to your findings. Now, if you find the defendant guilty of the offense charged in count 1 of the indictment, you will then make an additional finding as to the amount of methamphetamine that was involved. And there are 3 possibilities. You'll determine whether the amount involved was less than bulk amount, or 2, equal to or exceeding bulk amount, but less than 5 times bulk amount, or 3, equal to or exceeding 5 times bulk amount, but less than 50 times bulk amount. If your finding is not guilty, you will not make any finding on that issue. And under Ohio Revised Code Section 2925.01, bulk amount of methamphetamine is 3 grams. All right, that completes the substantive instructions. And just so you know, after I make a couple of corrections here on typos or cut and paste errors that I made, you will get a copy of the corrected instructions with you to have in the jury room, so that in case you aren't sure what I've said or have a disagreement, you can look and see what it is. So, at this time, we will now hear the closing arguments of counsel. And again, these are not evidence, but they are simply for the purpose of helping you to understand their positions and what they believe the evidence has or has not shown. The state of Ohio has the burden of proof, and so they have the opportunity to address you first, and then to offer a rebuttal to the defendant's closing argument. At this time, Ms. Collins, on behalf of the state.
May it please the court, Ms. Hapner, ladies and gentlemen of the jury, I first want to thank you for your time and attention to this case. While the case hasn't taken a long time, it is a very serious matter, and we are one of the few countries that uses a jury system to decide guilt that only works because of people like yourselves who take your duty seriously, and so for that I want to thank you. Now, as the court said, I have 2 opportunities to address you this afternoon, so I'll keep the first closing short and to the point. On September 20th and 24th, detectives and deputies with the Highland County Sheriff's Office and Highland County Task Force executed a search warrant at 148 Finner Ridge Apartments, apartment 3205 in Highland County. At the apartment at the time were Elizabeth Kibler and this defendant, Michael Carson, who was asleep in bed. He was asleep in bed in his underwear. There were shorts lying on the floor beside the bed that he was allowed to put on after detectives removed the items within the shorts and put them on the bed. After removing Carson and Kibler from the apartment, detectives and deputies took pictures and collected evidence. During the search of the bedroom, Captain Chris Bowen and Lieutenant Vincent Antonor found substances that they suspected was crystal meth. They found those substances in multiple locations, including containers that were found within the shorts that the defendant put on when he got out of bed, in a tissue box beside the bed, under the tissue box beside the bed, and in a cigarette pack from another bag that was found on the floor. After collecting the substances, deputies with the Sheriff's Office transported items to BCI, where chemical analyst Stanton Weisler tested and weighed the items, and you heard from him today. Per the BCI report and the testimony from expert witness Weisler, States Exhibits 2 through 7 all tested positive as methamphetamine, and when you add the weights of them together, which is outlined on the BCI report, they weigh over 22 grams. Bulk amount of meth is 3 grams. So in order to be at least 5 times bulk amount, it has to be 3 times 5. It has to be at least 15 grams. Again, when you add the weights together, the meth in this bedroom was over 22 grams. So this amount of meth is greater than 5 times bulk amount. Ladies and gentlemen, the state has proven each element of aggravated possession of methamphetamine in an amount greater than 5 times bulk amount, and the state has proven each element beyond a reasonable doubt. Thank you.
Ms. Hapner, on behalf of the defense.
Your Honor, Mrs. Collins, ladies and gentlemen, I also thank you for your time and attention. I think we've done a pretty good job of going through this case as quickly as we can, hopefully not taking up too much of your time, but we do appreciate the time that you have spent here. Probably when your list of things to do on a Monday morning, coming to court and listening to a criminal case is not tops, but I truly do thank you for this. If you recall, in my opening, I asked you to pay attention to the things that you will not hear from the state. You will not hear any testimony that Elizabeth Kibler and Michael Carson are married. They aren't. You didn't hear any testimony that Michael Carson is a resident of that apartment. He was asleep in bed there, but it doesn't make him a resident. You didn't hear any testimony of any drugs being found on his person. I also want to remind you that Mrs. Collins said in her closing, and Lieutenant Antonor testified to it in his direct examination, that they'd gone to the apartment to execute a search warrant. Well, that isn't actually correct. If you'll recall, when I cross-examined Lieutenant Antonor, he admitted that they arrived at the apartment and knocked on the door, spoke with Ms. Kibler, and got Mr. Carson out of the apartment prior to obtaining the search warrant. Keep that in mind. So that they had already determined what was in there, at least partially, prior to getting their search warrant. I'm going to ask you to, when you receive the jury instructions, to pay very careful attention to the definitions of knowingly and of possess or possession. The state has to prove beyond a reasonable doubt every element of the offense. The first element is knowingly. They have to prove that Mr. Carson knowingly possessed, and they're asking you to believe that he knowingly possessed 22 grams of methamphetamine. But let's look at this. This is not just one baggie of methamphetamine weighing 22 grams that they found in his pocket. There were several different baggies found in several different locations. And Lieutenant Antonor's testimony was that the really big amounts, this whatever 17 grams, was found in a blue case at the bottom of a tissue box on a nightstand on Liz Kibler's side of the bed.
Objection. Out. Objection.
He also found a baggie of methamphetamine in a cigarette container, cartridge, or not cartridge, but carton, along with several other items belonging to Liz Kibler, her driver's license, some prescription medication. Once again, not on the side of the bed where Mr. Kibler was sleeping, on the other side of the bed. It's easy to say, oh, it was within 4 feet of him, but let's think about it. Our beds are not that wide, and I don't know how many of you sleep alone or sleep with somebody else, but if you're sleeping with somebody else, your husband and wife, you're married, you got the wife's side of the bed and the husband's side of the bed. And it just kind of goes like that. So pay attention to that. They have to prove that he had possession, dominion or control over something that was in a case hidden in the bottom of a tissue box, not on the side of the bed where he was found sleeping. How likely does that seem? And I'm thinking not very likely. Mere proximity is not enough. They have to prove actual or constructive possession. So, looking here today, I'm looking at Ms. Lyle. You're about 4 feet away from Ms. Crowder. But you don't possess her purse. That's her purse. She possesses that. And I'm not picking her too. It's just that you're right in her front close enough. So think about that just being close to something does not mean that you possess it, have control over it, or dominion over it. So pay very careful attention to those definitions when you are deliberating today. And think, did he possess all of this meth? Some of it? None of it. That's a determination for you to make. You don't have to believe that he possessed 22 grams of methamphetamine simply because 22 grams of methamphetamine were found. So please pay very careful attention to the definitions of knowingly and possession in particular. Thank you.
Thank you, Ms. Collins. We have the state.
Thank you. So the first thing I want to address is the entire law that covers aggravated possession of meth. You guys actually get a written copy of it. Fortunately, it's one of the smaller laws in the state of Ohio. It's one of the shortest laws in the state of Ohio because some of them get very wordy. But aggravated possession of meth, 1 sentence. Did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine. That's it. So there are several things that maybe you didn't hear about, like that the defendant was a resident of the apartment or that they were married. Well, that's because the law doesn't say, did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, with a married person. There's no requirement that they be married. So we don't present evidence of that because it's not necessary. We only present the evidence to you that's necessary to prove the crime. And we've done that today. Now keep in mind the actual testimony. Not that they went to the apartment, they already knew it was there, and then they went and got the search warrant. That wasn't what the testimony was. The testimony was that they went to the apartment, they removed the residence to preserve evidence, then they had to wait for a judge to sign the search warrant, and we wish that it was quicker, I believe, is what Lieutenant Antonor testified to, but it's not. We have to wait. And when they did, then they went back and collected all the evidence out of the apartment. That was the actual testimony. And then Liz Kibler's side of the bed, actually that was never testified to in this trial. There was no testimony at all about whose side of the bed was whose or anything like that. Only that the defendant was asleep in the bed and had a lot of items in the bedroom that lent to the fact that he was staying there, like clothing in the closet, a bag, mail, things like that on the floor, mail, court documents, credit cards in a container on the nightstand, things like that. But there is no his side or her side of the bed. I'm not sure where that even comes from. And I'm sure that during the trial there were things that were touched on a little bit, and they weren't developed. There were questions weren't allowed to be asked and things like that. But I want to remind you of the judge's instruction. There are often legal reasons, there are often laws which don't allow us to go into some things. And you're not allowed to consider that. The only thing that you're allowed to consider is just like we talked in jury voir dire about. The testimony from that chair right there and the exhibits that were admitted into evidence, states exhibits 1 through 35, which you'll have copies of back there. Now, one of your main jobs as the jury is to determine the credibility of the witnesses. And again, there weren't a lot of witnesses today, so you only have 3 to think about. The ACI chemist who prepared a report sheet for you today, and you'll have that report to look at and how they do their testing and things like that. But it's not a lot of evidence, it's not a lot of testimony, and you have the report that outlines it all. And then you heard from the two detectives that searched the bedroom where all of this meth was found, in the bedroom where the defendant was asleep in bed in his underwear. Now, look at the elements of the crimes charged here. And again, it's one crime, one law, and one sentence. Did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine. And on or about September 20th of 24 in Highland County, Ohio, Michael Carson knowingly obtained, possessed, or used a Schedule II controlled substance in an amount equal to or exceeding, equal to or greater than 5 times bulk amount, but less than 50 times bulk amount. So, and we're talking about the meth. It's located throughout the bedroom where he was asleep when the officers arrived that morning. A person has possession when they know that they have the object on or about their person or in a place where it is accessible to his use or direction. 2 or more persons may have possession and together they have the ability to control it. Possession can be actual or constructive. Actual possession is like when a person has it within their immediate control. Constructive possession exists when a person is aware of the presence of the thing, is able to exercise dominion and control over the thing, even though it may not be with their immediate physical control. Proximity to an object may constitute evidence of constructive possession. Thus, the presence of an individual in the vicinity of the item, coupled with other factors or circumstantial evidence, are all probative of dominion and control in order to prove possession. I'm not just making this up. I don't have it memorized. I actually read it from your jury instructions. Carson and Kibler both could control these drugs. Carson is lying in bed with an arm's reach of the drugs on the floor that were in his shorts, and with an arm's reach of a tissue box where there's over 14 grams of meth. Now, just because all this meth isn't in his pocket as he's lying in bed does not mean that he does not possess it. Think of it this way. When you are laying in bed, your cell phone is usually someplace close, right? Like probably within arm's reach, maybe on the nightstand, maybe over on a dresser, but it's close, right? What if you charge your cell phone in the kitchen? Well, it's not in arm's reach anymore. It's on the other side of the house. But you still have constructive possession of the cell phone because it's your phone. You exercise dominion and control over that phone. Now think about this. 14 grams, that's how much. 14 grams of meth were found in the tissue box in the blue container. There's only one tissue box in this bedroom. Each person in the house, use your common sense, doesn't have their own tissue box. We all go to the same one in the house. We all exercise dominion and control over the tissue box in the house. It doesn't matter whose side of the bed it's on. It doesn't matter if it's in the kitchen, if it's in the living room, or if it's in the bathroom. We all go to the same tissue box. We all exercise dominion and control over the tissue box, just like this one. And again, this is within arm's reach of the person lying in bed in his underwear. And think about this. Several items that were removed from this defendant's shorts, they were wrapped up in shorts. This was the testimony of Lieutenant Antonorn. There were shorts on the floor, and there were items that were like wrapped up in them. So they picked those up, they dumped the stuff on the bed. The defendant asked to put those shorts on because he had on underwear. He puts on the shorts, and they take him out. And all the items that were in his shorts, they dumped in a pile on the bed. Lieutenant Antonorn identified those items in a picture, and Captain Bowen went through those items and found the grenade with the top that comes off that they found methamphetamine in. He found the camouflage little vial that had a trace amount of methamphetamine in it. They found the little black case, and again, you'll have the pictures. You also will have the pieces of evidence. The little black case that when they opened it up, it had baggies of meth in it. So, and all of that is in his things. So, let's use our common sense. This is strong. Another thing that were there that I forgot about just for a second. The scales that are used to weigh drugs. Well, yeah, pharmacists also have them. Mr. Carson's not a pharmacist. So the scales that are used to weigh drugs also found in his belongings. So you have a big quantity of methamphetamine in the tissue box and several smaller quantities in his belongings. Well, use your common sense. Lieutenant Bowen, Captain Bowen, who is assigned to the Highland County Drug Task Force and has been involved in thousands of drug cases, said they use that so they can weigh it out and make sure that this is the right amount, that this is what they're supposed to have. And who has those in a bag with their mail in it next to them in bed? This defendant. Now you must decide if this was bulk amount of meth, because we've proven that knowingly that he possessed it. You know, we talked about more than one person can possess it. We've talked about constructive possession, and being in the proximity of it is enough. More than one person can possess something, and it doesn't have to be in your hand like my pen is right now. Methamphetamine is a Schedule II controlled substance. Again, I'm not making this up. Your jury instructions actually tells you that. So is it bulk amount? Well, again, the jury instructions tell you on page 8, bulk amount, 3 grams. So it's really an easy finding. The BCI report, which you guys will have back there in the back room, tells you the weight right here. You don't have to remember it from what the expert said today. The weight is literally on here. 2 pages, tells you exactly how much added together. He quickly did it on the stand today. He rounded down, added together, and said definitely over 15 grams. That was his testimony. But when you add all these, the weights of State's Exhibits 2 through 7 together as outlined on that BCI report, I will tell you it's 22 grams. You can add it together yourself, but it's definitely greater than 15 grams. And because bulk amount is 3 grams, which again is on your jury instructions, page 7 to 8, bulk amount of meth is 3 grams. When you divide 22 by 3, because that's the total that you have, divide it by 3 because that's bulk amount, you're going to get 7.3, which is greater than 5 times bulk amount. It's easy. This is equal to or exceeding 5 times bulk amount of meth. You need to make sure that you mark that part of the verdict form, that it was greater, equal to or exceeding 5 times bulk amount, equal to or exceeding 15 grams of meth. Ladies and gentlemen, we've proven each and every element of this crime beyond a reasonable doubt, with the additional finding that it was equal to or exceeding 5 times bulk amount or 15 grams. Now, the state must prove each and every element of the crimes charged beyond a reasonable doubt. And the defense would ask you to see that reasonable doubt is almost impossible to overcome. That's just not the case. And we welcome that burden of proof. We welcome that when the evidence is this strong. You think about this as something that you practice in your everyday lives. We talked about this in jury voir dire. Let's talk about buying a car. You want an SUV. You want an SUV that's red. Your budget allows you to spend $400 a month on this vehicle. You shop around. You collect the evidence, just as being in a jury today, and you find a vehicle. The budget allows you, and the amount would be a $400 a month payment. The SUV only has 50,000 miles on it, and it is everything that you want in a vehicle. Now, there is some remote possible doubt that this is not the perfect vehicle for you. But the evidence and your reason and common sense says this is the right vehicle for me. And of course you buy it. It's not your job to look for reasonable doubt. If it had existed, it would have presented itself. It just doesn't. Reasonable doubt is doubt based on reason and common sense. And ladies and gentlemen, we have overcome that burden of proof in this case. And because we have overcome that burden of proof, and we have proven each and every element of this crime beyond a reasonable doubt, including the amount of methamphetamine, I'm asking you to use your reason and common sense and find this defendant guilty of aggravated possession of meth. Thank you.
All right, thank you. Now, ladies and gentlemen, you've heard the closing arguments of counsel. Again, I'll remind you they're not evidence. Now, I'm going to instruct you now on how to conduct your deliberations and prepare your verdict once you have reached it. Now, you must be uninfluenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh all the evidence and decide all of the disputed questions of facts, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all of the evidence and use your common sense to make findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so that the state and defendant will feel that their case was fairly and impartially tried. If during the course of the trial the court said or done anything you consider to be an indication of my view of the facts or the case in general, you're instructed to disregard that. My rulings are not intended to show partiality, but simply to lay down what the law is as the court finds. Now, your initial conduct upon commencing deliberations is a matter of great importance. It's not wise to immediately express a determination or insist upon a certain verdict, because if your sense of pride is roused, and you may later hesitate to change your position, even if you later decide that you may be or are wrong. Consult with one another, considering each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. You must each decide the case for yourself. You should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change your opinion if you find that it's wrong. However, you should not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinions of the other jurors. Now, you may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. Now, when you go to the jury room, your first function will be to select one of your number as a foreperson. That person you select will preside over your deliberations, but does not have any greater power, nor does that person's vote have any greater importance than anyone else's. Forepersons serve the purpose of helping you to conduct your deliberations in an orderly manner and give each juror an opportunity to express your opinion. As I've indicated previously, I will place in your possession the exhibits in verdict form, and the foreperson will retain possession of those, including the verdict, and return them to the courtroom when you are done. Until your verdicts are announced in open court, you're not to disclose to anyone the nature of your verdict. Now, with regard to the evidence, you will have these plastic bags. They're sealed. Don't open those. If you really feel you need to inspect them, let me know, and I'll make arrangements to have them opened in a court with someone who has gloves and take the proper precautions. So right now they're safe to look at, but if you need to open them, then let us know. Now, this being a criminal case, before it can be said that you have reached a verdict, it's necessary for all 12, and I'll repeat that, all 12, to agree upon a verdict. Now, in addition to the instructions, which is, as I said, once I make some corrections, I'll send it to you. You also have a verdict form, and I also need to make a couple of corrections on that, but it looks like this, has a name and case number, and it reads that it has a chart. And it reads, we, the jury, having been duly impaneled and sworn, find the defendant, Michael L. Carson, and then there's a blank space. You may be able to see it from there. And then it goes on to say, of aggravated possession of methamphetamine as he stands charged in count 1 of the indictment. And in that blank space, there's an asterisk there with some a reminder. That's where you fill in your verdict, either guilty or not guilty. Now, in this case, if there is a finding of guilty, only if there's a finding of guilty, then you're to make an additional finding as to the amount involved. And there's 3 possibilities here. And then, so the language, I'll read it to you, and then I'll explain to you how to report your verdict, or your finding, if your verdict's guilty. So it goes on to state that we further find that the amount of methamphetamine involved, and then there's 3 possibilities. Less than bulk amount, which is 3 grams, or was not equal to or exceeding bulk amount, or less than 5 times bulk amount, so that would be between 3 or more up to 15, or equal to or exceeding 5 times bulk amount, but less than 50 times bulk amount. And that would be over 15 grams. And so you're to strike out the language that does not apply to your finding. So, whichever one it is, if it's the first one, you strike out the last 2. If it's the second one, you strike out the first 3. First and third one. If it's the third one, you strike out the first 2. And that's what it will. That's the way it will be. Okay. And then after that, you must each sign your name in ink, and your signature indicates that this is your verdict and finding as for all 12 of you, because again, it has to be unanimous, or you don't have a verdict. Now, during deliberations in the jury room, you'll be in charge of the bailiff, and they'll ensure that your deliberations aren't interrupted. There'll be your means of communication with the court. I didn't say this earlier, but we don't permit any cell phones or any other type of electronic devices in the jury room. So as you go in the jury room, just put them there on the window sill, and the bailiff will be right there to make sure they're there when you leave. Bailiffs cannot answer any questions about the case. If you have any question or a request for something, write it down, knock on the door, give it to the bailiff, and then the bailiff will give it to me, and after I consult with the attorneys, I'll determine the response, return it to you in writing. Now, I can't promise you I can give you what you want. So, like, for instance, something that's occurred over my now almost 50 years of practice is jurors asking questions like, at what time did so-and-so arrive at the scene? Well, I can't answer that question. If there was no testimony about the time of arrival, then there is no testimony, and I cannot provide you something that's not in the record. I can only answer questions regarding to the instructions or deliberations, and most likely if you ask a question about the law, I'll probably send back a written response that says, take a look at page, whatever, paragraph, whatever, to explain. Because again, we know you're not lawyers, and you may not be able to find it as easily as I can. And that's just because I've been doing it a long time. It's my life. So, that's what I'm here for. Now, once you've reached a verdict, knock on the door, inform the bailiff, and then we'll assemble everybody back in the courtroom and then bring you back in to announce your verdict. Now, I want to thank all of you for your patience and your cooperation, and you've all been very attentive, and we've attempted to not waste your time presenting the case. The attorney's done a really good job in making sure that that has been done expeditiously. Keep in mind, the important thing here was that the case is presented fully. All right. Is there anything further, counsel? All right. So at this time, our alternates, Ms. Moon and Ms. Fair, you're going to be excused, but before you leave, I want to tell you this. You'll need to leave your phone number with the bailiff. And as they used to say in the movies, don't leave town, because in the event that something should happen, that one of these folks can't continue in deliberations, then we will call you. And so you would be first, Ms. Fair, and then, Ms. Moon would be first, and Ms. Fair would be second. And I've actually had to do that a couple of times since I've been a judge. And now the bailiff will call you once the verdict is returned so that you'll know. And then at that point, you'll be released from the instructions of the court. But until that time, you're to follow and abide by all the instructions I've previously given you about not talking about the case with anyone, reading anything about it, posting anything, don't do any research, or discuss it with anyone at all. Once the bailiff's notified you of a verdict, then you'll be released from that, and you may discuss it if you choose to. You don't have to, but you may. All right. So at this time, then, if Ms. Moon and Ms. Fair, if you would just come out around there and leave your number with the bailiff. And then, ladies and gentlemen, if you would, the jury, leave your phones on the windowsill and go to the jury room. I'll make these corrections on the forms and return or send those in to you along with the evidence. Thank you. Council approacher. I did a little change in the verdict form. It's the way I read it in the instructions, but I did it differently than what I showed you. I just took out the wording was or was not, because they're only going to make a finding if there is a guilty verdict. So what I did in order to simplify it, instead of the usual was or was not, I just have here that it was equal to or exceeding bulk amount, but less than 5 times bulk amount, equal to or exceeding 5 times bulk, but less than 50 times bulk amount, and or less than bulk amount is the first one for us. So I think that's simpler. I think the way I had it drafted before might have been might be confusing to the jury when it comes time to fill that in if they make a finding of
I would
guilty.
just put little lines where they can check the box.
I know, that's what I figured too, that's what you had done.
You know, I've never seen that done before.
I would feel like.
Yeah.
But I think that would be the easiest.
I do too.
Maybe in the future I can do that, but I'm not very good with the graphics. All right. So go ahead and send it back to them.
Did you change the statute number?
Back on record.
All right.
She stole that from me.
We have a question from the jury. Does he have a prior record? Obviously, that can't be answered. The way I would say is that there's no evidence in the record of that. There's no evidence in the record regarding that, so you may not consider it. Well, I don't know. I have to be careful.
Can you just say there's no evidence? There's no evidence in the record of a prior record.
Oh, that's not really though there is no evidence of it, but it's not because there's not a prior record. It's because the
No,
law
I
doesn't
understand
allow
that,
us.
but I can't answer the question
I understand.
in a way that tells
I
me he has a
understand,
record.
but
So what I think I have to do is say there's no evidence in the record for you to consider on this matter.
Yep.
Is that fair? Is that?
I think so, yeah.
I don't like that. Yeah, because the reason there's no evidence of it in the record is because we can't present evidence of it.
There's no evidence regarding this question in the record.
Yep.
Court may not supplement. I think that's about all I can say. Okay, here's what I'm going to say. There's no evidence regarding this issue in the record. You must decide the case based upon the evidence introduced, admitted at trial. That sound right?
Yep. Now the question is, will they be able to read your handwriting?
Say what?
Besides, usually.
Oh, I'm writing really, really good here.
I know, I would have been fine with, we can't answer that. Not.
Well, I'm trying to keep them from trying to read something into this. So, there's no evidence regarding this issue in the record. You must consider the evidence admitted during the trial. All right. Can you read that? Your school teacher. Good. I get a C.
Please rise.
Okay, we're back on record on State versus Michael Carson. I've had two additional questions. Question number 2. What is the law regarding, and then there's a little caret that says illegal above contents of a house with more than one occupant? And so my response is, please direct your attention to the instructions regarding possession on pages 6 and 7. Any objection to that?
No objection.
Question number 3, was the grenade found in his shorts? And my response to that is the court cannot answer any question regarding what evidence is in the record. Any objection to that?
No objection to that.
All right. Bailiff will take those back to the jury. Thank you.
Please rise.
All right, we're back on record. State of Ohio versus Michael Carson, and my understanding from the bailiff that the jury has announced they've reached a verdict. Is that correct? Yes. All right, bring the jury in, please. They already turned all this. They already turned this back in.
Yes, sir.
So for the record, the exhibits or jury instructions are lying on the bench. They kept in possession of the verdict form. Okay. Maybe you see the folks. Be seated, thank you. All right. Ladies and gentlemen, the court's going to inform you to return the verdict, and who is the foreperson? All right, Ms. Ross, if you would hand the verdict to the deputy clerk, please.
In the case of State of Ohio versus Michael L. Carson on count 1, aggravated possession of methamphetamine, we, the jury, having been duly impaneled and sworn, find the defendant, Michael L. Carson, guilty of aggravated possession of methamphetamine as he stands charged in count 1 of the indictment. Additional finding, if verdict is guilty, we further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. Is that okay? Yeah.
All right, ladies and gentlemen, the jury, you've heard the deputy read the verdict. Is this the verdict and additional finding of each and every one of you? All right. Wish the verdict or the count or jury to be polled?
No, Your Honor. No.
All right, ladies and gentlemen, the court will accept your verdict and enter a finding of guilty pursuant to that with the additional finding that you've made. I want to thank you for your service on this. These cases are serious, but you did obviously looked at it very closely and asked some questions, which is certainly an indication of your determination to do the right thing as best that you could, and the court appreciates your service. You will not be required to serve again the rest of this year. You're also exempt for an additional 1 year, which will be next year, from jury service in any court in this state. So if you were to get drawn for jury duty either here, which you shouldn't, or in a county or municipal court in Highland County, you can be excused since you served this year. And you'll be back in the pool in 27. So, all right. So you can go ahead and collect your phones and go downstairs to the clerk's office and collect your vouchers as well as any work institutions you may need. Thank you. Yeah. Thank you. And counsel, everybody will remain, please. so the verdict is guilty and finding a lower bulk less than 5 times bulk. That makes it
An F3.
F3, third-degree felony. All right. So the court will go ahead and proceed with sentencing. So the state have anything you wish to offer regarding sentencing?
Your Honor, we would ask the court to sentence the defendant to the maximum term for an F3, which would be 36 months. I will start by saying that Ms. Kibler had agreed to testify against the defendant today, and I prepped her for trial and then decided not to call her, not because she was going to hurt the state's case in any way. She is deathly afraid of this man. I will tell the court that during the evidence that was recovered in this case, some of the evidence that was recovered was from the defendant's cell phone, and it included some pretty violent videos of this defendant, for a lack of a better way to phrase it, just beating the crap out of her right in the living room. There are cameras throughout the house except for in the bedroom. Additionally, as the court knows, and the jury didn't have the ability to know, you know that the defendant's prior criminal history is, you know that he has been convicted of trafficking in methamphetamine as well as his priors in Florida. So based on that information, we do feel that a maximum sentence to this charge is a suitable sentence. And I did want to just make the court aware that Ms. Kibler was willing to testify. I didn't call her out of my own, not because she was going to not be helpful to my case, but just how I observed her to be when she was around him. Now, and one additional thing, Your Honor, I have listened to Mr. Carson's phone calls from the jail, and despite this court's order that he have no contact with Elizabeth, every single day he called the phone number of the person where she was staying. And while Elizabeth didn't get on the phone with him directly, it was constantly, we'll tell her this, we'll tell her that, well, what is she going to testify about? Well, what is she going to say about me? And, you know, this and that and the other. That's why I asked the court to remind him of that admonition. He just has no respect for the authority of the court. Thank you.
Ms. Hapner?
Thank you, Your Honor. Mr. Carson was on community control for a case earlier this year. He was at the STAR program, and my understanding is that he was doing well at STAR, and that he would like to go back there to finish that program. So we would ask for a sentence of community control and completion of the STAR program as a part of that. Thank you.
All right. Mr. Carson, anything you'd like to say?
No, sir.
No. Well, Mr. Carson, you know, obviously at the time you were placed on community control in your other case, this case was not known to the court, and the conduct that is exemplified in this case, as well as the fact of what the prosecutors indicated, that you know you were making threats against your co-defendant, which appears to work because she didn't testify against you, and I think that's the basis of the jury's finding, is that because 14 grams were found in the tissue box on the other side of the bed, that's I think why they came up with the decision that they did. And so I don't have any doubt that based upon just the evidence in this case, as well as looking at the whole picture, you know, that you were most likely selling dope, selling drugs. You have previous for that 2 counts, 3s, and in this case, they just had you on the possession. And your co-defendant has pled guilty to the charge, which is an actual incarceration. So it seems appropriate to the court that since this is a joint effort, that it is appropriate that you be sentenced to 3 years, the maximum sentence. The court will also note that you had previous felony conviction in Escambia County, Florida, in addition to the conviction in this court in the other case. And the court will also note that there was scales that were recovered from your belongings, and sort of that would be an indication of trafficking. So it's ordered the court that you be and are hereby sentenced to a term of 3 years, 36 months at the Correction Reception Center in Orion, Ohio. And you'll be given credit for time served since your arrest, which would have been on July the 31st, I believe. Is that correct? Oh, no, it's earlier than that.
I think it's July 11th.
Yeah, July the 11th. I don't know why they have it here. Oh, okay, I see what happened. They had it in on, he had booked in on the 11th on the theft charge, which was dismissed, so that's still part of the same case, so they get credit for that. So from the July 11th to today would be 31, August of 22 and September. So that's 74 days. On completion of your prison term, Mr. Carson, the Adult Parole Authority may place you under post-release control for a period of up to 2 years. If they do, you'll be supervised by a parole officer on the terms they set, and if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to, in this case, 9 months for any one violation, with a cap of half of your prison term for all violations. However, if you commit a new felony while under post-release control, then in addition, whatever sentence the judge in a new case can impose upon you, the judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively as sentence in the new case. You're also ordered to pay the court cost, which judgment, grant, and execution is ordered. Has there been any change in your financial circumstances since I appointed Ms. Hapner to represent you? All right, then the court will find that you're presently unable and unlikely to be able to pay the mandatory fine in the near future, so that fine will be waived. Now, in your other case that you're on community control for, this isn't a violation of that, since it was you were on community control before this was, or after this offense was committed. But while you're in prison, the court's going to toll your community control starting today, and it'll be tolled until such time as you're released from prison, and then on that you'll be required to complete the rest of the community control, and you're to report to the probation department by the end of the next business day after you are released. And then you'll be required to comply with all those conditions in that. Now, Mr. Carson, you have a right to appeal the judgment in the case, the verdict of the jury, and the sentence, and any other matters you feel may have been prejudicial against you, unconstitutional, unlawful against you. You must file that appeal within 30 days. If you do not have the money to pay to have the appeal filed or provide the papers and record that's necessary for your appeal, the court will provide those for you at no cost. You're also entitled to have an attorney to represent you, and the court will appoint an attorney for you based upon your previous finding if you decide to appeal. Now, typically the attorney that handles the case doesn't file the appeal, but in terms of if you do wish to file an appeal, I suggest you discuss that with Ms. Hapner before you're transported, so that she can file that for you to protect the record, only for purposes of protecting your right, and then the court would appoint, unless you decide you want to handle the appeal. If you don't want to handle the appeal, just say so in your notice that you're filing it limited and then purpose, and the court will appoint counsel to represent you at no cost, Mr. Carson. All right. Is there anything further from counsel?
No, Your Honor.
Okay. You're remanded to custody then. Thank you.
Judge, can we go back on the record just for a moment?
You what?
Go back on the record just for a moment?
Yeah.
I did want to tell the court there was cash found in this apartment. You can't say who it belonged to, one way or the other. We may have to handle this after Ms. Kibler is sentenced. But if the court wants to order that paid toward his court costs, I could.
Well, any cash that's in custody of the department that Mr. Carson has a claim to will be ordered to be subject to any claims of Ms. Kibler. will be ordered to be used to pay court costs first and then to reimburse the county for the appointed counsel. And then ballots will be held and be distributed depending upon whose ownership is claimed. All right. How much were we talking about?
I'm not sure. I'd have to add it up. It's not, I'm sure less than $2,000.
Okay. All right. Thank you.
Please rise.